Hello friends! Are you considering using a recording device in order to possibly record conversations between you and your soon-to-be ex-spouse? Well, proceed with caution, and in the words of the old school cartoon Elmer Fudd, be very, very quiet and careful. Today we're going to talk about the use of recording devices during divorce proceedings. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, so as we jump right into the use of recording devices during a divorce proceeding, we must briefly discuss the different wiretapping laws which govern when recording an individual is permissible or okay. In general, any state can be categorized either as a one-party consent or a two-party consent jurisdiction. In a one-party consent jurisdiction, only one party or one person that is involved in the conversation must consent to the recording of that conversation. So it's a lot easier. And in these one-party consent states, it's oftentimes more valuable and legal to be able to record conversations between the spouses and then maybe use that later on in court. However, even in these one-party consent jurisdictions, it is still unlawful to intercept and record a conversation to which the person who is recording is not a party to that conversation. So if one of the spouses records the other spouse having a private conversation with either her legal team or some witnesses on the case or with a friend, that still may be considered illegal even in a one-party consent jurisdiction. On the contrary, in a two-party consent jurisdiction, all parties captured on the audio, meaning anybody and everyone that's on that audio recording, must know and consent to being recorded. A person who records another without permission could expose themselves to very serious criminal penalties as a result. And certainly, or most certainly, the audio file that was obtained without permission would probably not be admissible in court. Also keep in mind that states in both types of jurisdictions typically apply exceptions for communications that are captured either by the police, emergency service personnel, and the like. Now, when it comes to the state of Florida in particular, the state of Florida is a two-party consent jurisdiction. So we've come up to the $64,000 question, and that is, can you record your spouse to try to use those recordings as evidence against them in a divorce proceeding? Well, the answer is a little complicated. When it comes to the one-party consent jurisdictions, we're not saying that you should record your spouse, but it seems like if you record them and want to use it as evidence, it is a lot easier. The recordings seem like they would be admitted because it only takes one person to decide that they want to record that conversation. So any conversations between the spouses that are recorded will probably come in. When it comes to the two-party consent jurisdictions, the answer is sometimes. Now, obviously, if you and your spouse agreed to a recording, let's say that you had an in-depth conversation about a time-sharing schedule before you got a divorce or before the divorce proceedings happened, both parties were aware of the recording and both parties consented to the recording, well, at that point, it seems pretty clear that even if it's a two-party consent jurisdiction, the conversation would come in. Now, let's talk about some of the possible exceptions to the knowledge and consent requirements for a recording in a two-person consent jurisdiction. The first one that often comes to light is the expectation of privacy exception, where there is a reasonable expectation of privacy for the conversation at hand. Let's say the spouses are having a conversation at their dinner table in their home or in their bedroom, then they can reasonably expect for there to be privacy, and those type of conversations cannot be recorded without either spouse's knowledge or consent. However, if the spouses are having a sensitive conversation either about child custody or some serious other conversation in public, let's say on a train or in the supermarket, In that situation, there is no reasonable expectation of privacy. Therefore, it is possible and it may be acceptable to record anything that is said during that conversation. Another great example is, let's say there's a court hearing. One of the spouses is upset about the ruling of the court. The parties go outside, and in front of the courtroom, they start yelling. At that point, I think it's fair game for the other spouse to record that type of behavior. The next exception to the knowledge and consent requirements prior to recording in a two-party consent jurisdiction is what oftentimes is termed the received information exception. It kind of is what it sounds like. If your spouse gives you information, then that information may be admissible in court, and it probably will be. This is true if your spouse gives you that information even by accident. So let's say they're sending an email to someone on their legal team, or their forensic accountant, some witness that they have, and they send the email to you. If it's sent to you, fair game. If a recording is made on one of the spouse's voicemails in air, maybe that spouse was trying to call somebody. If that recording is made on the other spouse's voicemail, it seems like that would be fair game as well. So that's a little bit of a tricky exception whenever one spouse voluntarily gives information to the other. The next question that follows is, what if a person records their spouse without their knowledge or consent? I always think this is a bad idea. In a two-party consent jurisdiction, anyone that records the spouse or the other party without their knowledge or consent does so at their own risk. In Florida, it is a criminal act to record someone without their knowledge and consent. It's actually a felony. And if you disseminate that information, the recording, if you pass it on to third parties, that is another crime. In addition to this, there are heavy fines and legal penalties in both civil and criminal court that a person can face. And not to mention that if a judge finds out that you are recording the other spouse without their knowledge or consent, the judges in a divorce case may look disfavorably upon a party for doing that. The court may behave more harshly towards you since you broke some of the rules. So tread carefully, friends. All right, so before we conclude, let's talk about the other types of communications or recordings that often appear between spouses during a divorce proceeding. Starting with text messages that are sent between the spouses may generally be saved and used in court. So be careful what you say on these messages. Generally, the courts look at text messages as though they are correspondence. And what's on those text messages oftentimes can contain admissions, threats, or evidence of inappropriate behavior. So a lot of times these messages are compelling evidence during a court proceeding, especially when it revolves around the children or the misuse of finances. Up next are voicemails. That's right. All of these audio files are likely to be held up as evidence in courts during a divorce because the person who left the voicemail, the speaker, undoubtedly knew that he or she was being recorded when they left that voicemail. So voicemail messages are great pieces of evidence because they oftentimes can convey emotions that can be admitted into court. There's nothing better to admit as an attorney than a voicemail message that shows a person enraged or aggressive or acting out of their mind, to convey to the court that this person may not be the best parent to have a custody of a kid or a child, or this person may not be behaving as they are appearing in court. So voicemail messages are a very compelling piece of evidence. Up next are emails. That's right, the email communications between the spouses from one spouse to the other will probably be admitted in court as evidence in a divorce case. The same rules and philosophies about the text messages usually applies. It's pretty much correspondence between the different spouses. So watch out how email correspondence is sent to the different spouses when someone is going through a divorce. Another great example is applications like Talking Parents. Oftentimes are court ordered, and it allows the parties to communicate on a platform that the parties, the attorneys, any guardian ad litem or experts for the children, and the courts can all log on and see what happens in the conversation. So those messages can be downloaded, printed, and used as evidence as well. The next group of communications that may be relevant are the social media posts. We did a whole video of how not to behave on social media when you're going through a divorce, but social media platforms are broadly considered to be public platforms. So if one of the parties gains reasonable access to a spouse's social media post, these posts can be admitted into evidence. The platforms include Facebook, X, which was formerly known as Twitter, Instagram, and others can be used as compelling evidence in a divorce case of all types of conduct from the spouses. There are some exceptions though. So one spouse is not allowed to hack into, for instance, a Facebook of the other spouse and then use that against them. Now we're going to wade into a very sensitive topic, and that is recording children during a divorce. Oftentimes parents think it's a good idea to record their children during a divorce proceeding to try to use that as evidence of inappropriate conduct or bad parenting. Remember that recording children, especially without their knowledge or consent, can raise significant ethical and legal concerns. In a one-party consent jurisdiction, some of those states grant the parents vicarious authority to consent to the recording of the conversations that they have with the minor children. But in a two-party consent jurisdiction, this is impossible. In that type of jurisdiction, both parents would have to consent to the recording of the children. That child whose conversation was captured by the audio did not consent. Both parents did not consent, and it is very highly unlikely that a court would admit that evidence into a court proceeding on a divorce. So be very careful with that. Additionally, involving children in the process of gathering evidence of one spouse against the other in a divorce proceeding can have very serious emotional and psychological consequences for the children. It is explicitly involving them in the litigation. You're putting them on video and using that video against the other parent. When it comes to legal matters involving children in a divorce proceeding, courts typically will prioritize the best interests of the children, and that typically won't be for the children to be allowed to be recorded, especially if it's not consented to by both parents. The courts will look at what the person recording the minor children's conversation, what their motive was, and if the child is mature enough to make judgments about whether or not they should have been recorded. So the answer for an older child may be different than a younger child, but more importantly, if one of the parties has concerns about the well-being of the children during a divorce, it is generally more appropriate to follow the proper legal channels, which is to file an appropriate motion, seek advice of a guardian ad litem, or call Child Protective Services if necessary. All right, so that's all, folks, on using recording devices during a divorce proceeding. If you know anyone that would find this information helpful, please forward this video to them and have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Please do us a favor and like this video, subscribe to the Divorce Broadcast, and if anybody has any comments, especially the stuff about recording people when they don't know and how they feel about recording children in divorce proceedings, drop us some comments so that we can respond and engage in that conversation as well. Take care.